The nuclear takeoff of XRP is closer than it has ever been. Regulations are beginning to take effect, and the lawsuit is moving closer to being resolved. And while we are on the subject, the Securities and Exchange Commission (SEC) is once again facing criticism. As of today, the Blockchain Association and the Crypto Freedom Alliance of Texas have filed a lawsuit against the Securities and Exchange Commission (SEC), requesting that the courts invalidate the expansion of the dealer regulation that is vague and arbitrarily implemented. This rule is problematic because it hinders innovation. The growth of the digital asset business is harmed, and the Securities and Exchange Commission is given the confidence to lead by unwritten norms and direction. So once again, the Securities and Exchange Commission (SEC) is being sued for its illegal actions, and an increasing number of people are speaking out against the man, Gary Gensler. In the first 3 years that Gensler has served as head of the Securities and Exchange Commission (SEC), the agency has been sued for abusing its rulemaking authority more times than the SEC has been sued in the preceding 10 years or more, which spans the term of 3 long-serving chairmen combined. This is something that we can see from Ripple's chief legal officer, Stuart Alderati. You cannot tell me, or anyone else for that matter, that Gary Gensler does not have some kind of personal goal, some kind of corruption in his midst, because his desire for $2 billion from Ripple in fines is just another evidence of his hallucination, if you will. This is so absurd that you cannot convince me. In spite of this, the Securities and Exchange Commission (SEC) has not yet been successful in winning a legal battle, and Ripple has been the company that has been leading this charge. In my most recent video, I highlighted that in response to the outrageous request of $2 billion, XRP stated that the maximum amount of penalties will be no more than $10 million. This decision represents the opposite end of the spectrum. As of right now, Jeremy Hogan, an attorney who advocates for XRP, has stated that there is the potential for a settlement between Ripple and the SEC that would amount to $100 million. This would be an enormous victory. But listen with great attention. Before Gobble, the Securities and Exchange Commission (SEC) was requesting $1.95 billion, and Ripple has stated that not only should there be no injunction, but it should only be required to pay a total of $10 million. This is due to the fact that no one was harmed, and the SEC is unable to prove that any harm was caused to the investors or purchasers. Additionally, Ripple believes that $10 million would be a reasonable penalty based on previous penalties. I would suggest that based on what we have seen so far in the case, the final judgment will be released this summer, with my prediction being that it will be around July or possibly August. After that, regardless of the result, I believe that both parties will file notices of appeal, and the case will be brought before the DCA Appeals Court, where it will be decided after the next year. Now, if I were the Securities and Exchange Commission, I would not appeal it because I believe that lousy facts make terrible law, but that is just me. This is something that I am not sure the SEC can just let go of. To them, everything appears to be so deeply personal. In any event, I have the authority to decide whether or not $100 million and an injunction on the establishment of sales. Therefore, as you have heard, the question that truly matters is whether or not the Securities and Exchange Commission will continue to fight this battle that appears to be losing. It would appear that Gabby Gensler has taken this matter very seriously, so who knows what the future has for her. However, as a result of a court judgment from the previous year, Ripple was required to transfer all of its US ODL customers from XRP to USDT Tether. And now, as suggested in this video by Zach Rector, Ripple will burst in popularity in the United States very, very soon, heating up US ODL and most certainly flipping the switch owing to the launch of a Ripple stablecoin. However, the verdict appears to be only a few months away. They are going to move all of their customers over to XRP from USDT, and on account of the regulations which are becoming very, very close, the nuclear takeoff of XRP is getting closer than it has ever been, and it may be just a few months away. As we can hear in this video, pay close attention to what is being said. You may say that these are the 2 dates. I simply wanted to be completely upfront and explain that June is coming up, which is in 2.5 months. For the 2 asset classes that we discussed, if you are a stablecoin issuer, you should know that when we talk about June, you are essentially referring to the month of June. It is necessary for any issuers or any of the e-money tokens or R tokens to be in compliance with MiCA by the time the 2.5 months have passed. The month of December is the second deadline that is highly essential. We have till the end of this year to ensure that all of the assets, including the CASPs, are in compliance with MiCA.